The moment I saw the HOA president standing on my property with a surveyor and 2 board members, I knew they were up to something. I had just finished installing a professional-grade snowmobile track on the back 40 acres of my land in northern Minnesota, just outside Bemidji, and these vultures were circling like I had built a nuclear power plant instead of a winter sports facility. My name is Frank Jennings, and I had spent the last 6 months of my life turning my dream into reality. After selling my tech startup in Minneapolis for a comfortable sum, I bought 300 acres of pristine wilderness property. The land was perfect for what I had in mind. Rolling hills, dense pine forests, and enough snow from November through March to make any winter sports enthusiast weep with joy. I wanted to build a snowmobile track where I could host races, practice runs, and eventually maybe even regional competitions. I had done everything by the book, got all the proper permits from the county, environmental clearances, and even hired engineers to ensure the track would not cause erosion or drainage issues. But here was Patricia Hendricks, the HOA president, standing on my land like she owned the place. She was the textbook definition of a Karen. Mid-50s, bleached blonde hair cut in that distinctive speak-to-the-manager style, oversized sunglasses perched on her head despite the overcast Minnesota sky, and a permanent expression of disapproval etched into her face. "Mr. Jennings," she called out as I walked toward them across the newly groomed snow, "we need to have a serious discussion about this track you have built." I stopped about 10 feet away, crossing my arms. "Patricia, you are on my private property. Unless you have business here, I need you to leave." Her face flushed red, which was quite a feat considering the temperature was hovering around 15 degrees. "This is HOA business. We have received numerous complaints about the noise, the traffic, and the environmental impact of what you have constructed here." I looked around at my vast, empty property. The nearest house in the HOA community was almost a mile away, and my land was not even technically part of their development. When I bought the property, the previous owner had been tricked into signing HOA documents years ago, but my lawyer assured me that since my land was purchased after the fact and was clearly outside the platted subdivision boundaries, I had no obligation to the HOA. First of all, I am not part of your HOA. Second, there is nobody close enough to be disturbed by anything I do here. Third, I have all the county permits, so again, please leave my property. The surveyor, a nervous-looking guy in his 30s, was looking increasingly uncomfortable. Patricia ignored him and stepped closer to me. "Actually, Mr. Jennings, we have done our research. The original property boundaries of the Pinewood Lakes community include portions of what you claim is your land. This track you have built sits partially on HOA common area, which means we have every right to demand its removal or compensation." My blood ran cold, but not from the winter air. "That is absolutely false. I had a survey done before I purchased, and another one before I started construction. This is entirely on my property." She pulled out a rolled document from her designer handbag. "This is a survey from 1987 when the Pinewood Lakes community was first established. As you can see, the northern boundary extends well into what is now your track area. We are not unreasonable people, Mr. Jennings. We are willing to discuss terms." "Terms?" I asked, my voice dangerously quiet. "Yes, we believe this facility could be a valuable amenity for our community. If you are willing to turn over management and operational control to the HOA, we will not pursue legal action for your unauthorized construction on our land. You will, of course, be responsible for all maintenance costs, insurance, and liability, but the HOA will collect all fees from usage and events. I stared at her in disbelief. You want me to give you my track, pay for everything, and you will keep all the revenue? We are not asking you to give us anything, Patricia said primly. We are simply claiming what is already ours. The track is on HOA land, therefore it belongs to the HOA. We are being generous by allowing you to maintain it. The surveyor she brought with her finally spoke up. Madam, I should mention that I have not actually verified these boundaries yet. The document you showed me was just a preliminary plat map. I would need to do actual field work to confirm. Patricia shot him a look that could have frozen Lake Superior. Your services are no longer required. Send me your bill. The surveyor did not need to be told twice. He practically ran back to his truck. I pulled out my phone. I am calling my lawyer. Do not touch anything on this property, and I want all of you off my land right now. Patricia smiled, and it was not a pleasant expression. We will be filing an injunction tomorrow to halt all operations on this track, pending resolution of the property dispute. I suggest you lawyer up, Mr. Jennings. The Pinewood Lakes HOA does not lose. They left, and I immediately called my attorney, Robert Chen, who had handled my property purchase. He was a sharp lawyer out of Duluth who specialized in property law. Frank, slow down, he said after I finished my rapid-fire explanation. They are bluffing. I personally verified those property lines. There is no way the HOA has any claim to your land. She had a surveyor with her, Robert, and some document from 1987. Send me whatever you can get your hands on. I will look into it immediately. In the meantime, do not stop using your track. If they file an injunction, we will fight it, but do not give them any ground by voluntarily ceasing operations. That could be seen as an admission that their claim has merit. Over the next week, things escalated quickly. Patricia was true to her word. The HOA filed an emergency injunction in Beltrami County District Court, claiming that I had constructed an unauthorized facility on HOA common land, and that the noise and traffic posed a danger to the community. The hearing was set for 2 weeks out. But Patricia was not content to wait for the legal system. 3 days after our confrontation, I woke up to find a chain and padlock on the access road to my track. The road was entirely on my property, cutting through the woods from the main county road to the track facility. Someone had put up a professional-looking sign that read, Private Property Pinewood Lakes, HOA No Trespassing. I called the sheriff's department. Deputy Martinez arrived within 20 minutes. Mr. Jennings, do you have documentation proving this road is on your property? She asked. I showed her my survey, my deed, and the property tax maps. She examined them carefully, then took photos. Okay, that is pretty clear-cut. This is trespassing and possibly criminal mischief. Do you know who put up this chain? The HOA president threatened to shut down my track. She is the only person with motive. Deputy Martinez nodded. I will pay her a visit. In the meantime, you have every right to remove this chain from your property. I had bolt cutters in my truck and made short work of the chain, but the incident made me realize how far Patricia was willing to go. This was not just about property lines or community standards. She wanted my track, and she was going to use every dirty trick she could think of to get it. Robert called me that evening with news. I dug into that 1987 plat map Patricia referenced. It was a preliminary survey that was never officially filed. The actual recorded plat map from 1988, which is the legal document, clearly shows the HOA boundaries ending well before your property. She is using a meaningless piece of paper to try to intimidate you. Can we use this in the injunction hearing? Absolutely. I am also filing a countersuit against the HOA for harassment, defamation, and interference with business operations. You told me you already had bookings for the track, right? Yeah, 3 snowmobile clubs have reservations for January and February. And I was in talks with the Minnesota Snowmobile Association about hosting a regional event in March. Perfect. Document every lost opportunity, every cancellation, every bit of damage their actions cause. We are going to make them pay for this. The injunction hearing arrived on a brutally cold January morning. The courthouse in Bemidji was a stately brick building that had seen better days. Judge Anderson was presiding, a no-nonsense woman in her 60s who had a reputation for not tolerating frivolous lawsuits. Patricia showed up with the HOA's lawyer, Dennis Morgan, a pompous guy in an expensive suit who clearly thought this was going to be an easy win. The HOA had also brought several board members and what looked like half the community. They packed the courtroom gallery, clearly trying to intimidate me with numbers. Robert and I sat at the plaintiff's table, and I had brought my own documentation. Property surveys, permits, emails, everything that proved my track was legal and on my land. Judge Anderson called the court to order. This is a hearing on the Pinewood Lakes Homeowners Association's emergency motion for a temporary injunction against Frank Jennings. Mr. Morgan, you may present your case. Morgan stood, smoothing his tie. Your Honor, this is a simple matter of property rights. The defendant, Mr. Jennings, has constructed a large commercial facility that encroaches on HOA common land. We have survey evidence showing that the northern portion of his tract crosses into community property. Furthermore, this facility poses noise pollution, environmental hazards, and traffic concerns for our quiet residential community. He presented the 1987 preliminary plat map with great fanfare, as if it were the smoking gun. Judge Anderson examined it. This appears to be a preliminary survey. Do you have the recorded plat map? Morgan hesitated. Your Honor, this document clearly shows the original intent of the community boundaries. That was not my question. Do you have the legally recorded plat map? We do, but it was subject to changes and negotiations that were not properly documented. Robert stood up. Your Honor, may I? Go ahead, Mr. Chen. Robert approached with his own documents. This is the officially recorded plat map from the Beltrami County Recorder's Office, dated April 1988. As you can see, the northern boundary of the Pinewood Lakes community ends at this line, which is approximately 300 feet south of Mr. Jennings's property line. There is no overlap, no encroachment, and no legal basis for the HOA's claim. He also presented my property survey, which had been prepared by a licensed surveyor and recorded with the county. The two documents aligned perfectly, showing a clear boundary between the HOA land and my property. Judge Anderson studied the documents for several minutes. Mr. Morgan, this recorded plat map contradicts your preliminary survey. Why should I give any weight to an unrecorded document when we have official records? Morgan sputtered. Your Honor, the intent of the original developers was clear. The community was meant to extend to the northern ridge line, which would include the defendant's tract location. Intent is meaningless without legal documentation. Do you have any recorded easements, covenants, or deed restrictions that support your claim? We are in the process of researching the historical records. Robert jumped in. Your Honor, the HOA is on a fishing expedition. They have no legal claim to my client's property and they know it. This injunction is being used as harassment to try to force Mr. Jennings to give up his legal rights. Patricia suddenly stood up in the gallery. He is ruining our property values. That track is an eyesore and a nuisance. Judge Anderson fixed her with a stern look. Madam, sit down. You are not representing yourself in this proceeding. Morgan put a hand out to calm Patricia. Your Honor, Even if the property boundary is disputed, there is still the matter of the noise and traffic impact on our community. Robert responded immediately. Mr. Jennings's property is over a mile from the nearest HOA residence. The county noise ordinance allows for recreational activities during daylight hours, and my client has never operated the track outside those hours. As for traffic, the access road is entirely on his private property and does not pass through any HOA streets. Judge Anderson looked at Morgan. Do you have any evidence of actual noise complaints filed with the county? The HOA has received numerous complaints from residents. That was not my question. Have any residents filed formal noise complaints with the appropriate county authorities? Morgan shuffled his papers. Not to my knowledge, Your Honor. So we have no verified noise violations, no property boundary documentation supporting your claim, and no legal basis for this injunction. Is there anything else? Morgan looked desperate. Your Honor, we believe there may be environmental violations. The construction of this track required significant land alteration. Robert handed the judge another document. Mr. Jennings obtained full environmental review and approval from the Minnesota Pollution Control Agency before beginning construction. The track was designed by environmental engineers to minimize runoff and preserve the natural drainage patterns. All permits are current and valid. Judge Anderson reviewed the permit documents. Mr. Morgan, this is one of the most thoroughly documented private land use cases I have seen. Your client has brought this emergency injunction without any legal foundation whatsoever. Motion denied. Patricia gasped audibly from the gallery. Morgan tried to salvage something. Your Honor, we request that the property boundary dispute remain open for further investigation. You can investigate all you want, but do not waste the court's time again without solid evidence. This hearing is concluded. As we left the courtroom, Patricia blocked my path. This is not over, she hissed. You do not know who you are dealing with. Actually, I do, I replied calmly. I am dealing with someone who is about to be on the receiving end of a very expensive lawsuit. Over the next month, things got worse before they got better. Patricia launched a campaign of harassment that was almost impressive in its petness. The HOA filed complaints with every county and state agency they could think of. The Building Department, the Environmental Quality Board, the Department of Natural Resources, even the State Fire Marshal. Each agency had to send inspectors, and each time they found nothing wrong because I had already obtained all the necessary approvals. But the inspections cost me time and money. I had to cancel 2 scheduled events because inspectors were on site. The constant stream of complaints also made some of my potential clients nervous. 2 snowmobile clubs canceled their bookings, citing concerns about the legal situation. Robert filed the countersuit as promised. We were suing the HOA for harassment, defamation, tortious interference with business relationships, and abuse of process. The damages we were seeking included lost revenue from canceled events, attorney fees, and punitive damages for the HOA's bad faith actions. Patricia's response was to double down. She started posting on social media, warning people about my dangerous, illegal track, and claiming I was destroying the environment. She created a Facebook group called Stop Frank Jennings that attracted a few dozen members, mostly other HOA busybodies from around the state. But then she made a critical mistake. In one of her Facebook posts, she wrote, "Frank Jennings is a con artist who stole HOA land to build his track. He has no permits, no legal right to operate, and is putting children at risk. We will force him to shut down by any means necessary." Every word was demonstrably false, and it was in writing. Robert immediately added defamation per se to our lawsuit and filed a motion for a temporary restraining order against Patricia personally, arguing that her campaign of falsehoods was causing irreparable harm to my business. The hearing for the restraining order was scheduled for early February. In the meantime, I decided to go on the offensive in the court of public opinion. I created my own website documenting everything. I posted all my permits, all the court documents showing the HOA's claims were baseless, and a timeline of Patricia's harassment. I also posted photos and videos of the track itself, showing how professionally designed and environmentally conscious it was. The website got picked up by some local media. The Bemidji Pioneer ran a story titled, "Local Businessman Fights HOA Overreach." The article was balanced, presenting both sides, but the facts were clearly in my favor. The reporter interviewed several county officials who confirmed that I had followed all the proper procedures and that the HOA had no jurisdiction over my property. Patricia did her own interview, claiming the media was biased and that I had somehow bought off the county officials. She came across as unhinged, and even some of the HOA residents started to distance themselves from her. The restraining order hearing was almost anticlimactic. Judge Anderson reviewed the social media posts, listened to Robert's arguments about defamation and harassment, and granted a temporary restraining order prohibiting Patricia from making any public statements about me or my business, pending the resolution of the defamation lawsuit. Patricia was furious. "This is a violation of my First Amendment rights," she shouted. Judge Anderson was unmoved. "You have the right to free speech, Miss Hendricks, but you do not have the right to publish demonstrable falsehoods that damage someone's reputation and business. If you violate this order, you will be held in contempt." That should have been the end of it, but Patricia could not help herself. 2 days after the restraining order was issued, she posted on Facebook again, "I have been illegally silenced by corrupt judges protecting Frank Jennings, but the truth will come out. He is still operating his illegal track on stolen land." Robert filed a motion for contempt that same day. The hearing was scheduled for the following week, but before the contempt hearing could happen, Patricia made an even bigger mistake. She decided to take matters into her own hands. I was at the track on a Wednesday afternoon, grooming the snow and preparing for a private event that weekend, when I heard the sound of heavy machinery. I drove my grooming machine back to the maintenance building and saw a bulldozer driving onto my property, heading straight for the track. I jumped off the groomer and ran toward the bulldozer, waving my arms. The operator saw me and stopped. I could see Patricia sitting in a pickup truck behind the bulldozer, along with 2 other HOA board members. "What the hell are you doing?" I shouted at the bulldozer operator. He climbed down from the cab, looking confused. "I was hired to do some land clearing. The lady said she owned this property." "She does not own anything here. This is my land and you are trespassing." The operator looked back at Patricia, who was getting out of her truck. "Madam, is this true?" Patricia marched over. "Do not listen to him. The HOA has legal authority over this land, and we are exercising our right to remove this unauthorized structure." I pulled out my phone and called 911. "Yes, I need sheriff's deputies immediately. Someone is attempting to destroy my property with heavy equipment." The operator looked alarmed. "I am not destroying anything until this gets sorted out." He climbed back into his bulldozer and turned off the engine. Patricia turned on him. "I am paying you to do a job. Get back to work." "Lady, I am not going to jail for you. This guy says it is his property and he is calling the cops. I am out of here." He started the bulldozer and began backing it toward the road. 2 sheriff's vehicles arrived within 10 minutes, lights flashing. Deputy Martinez was there again, along with another deputy I did not recognize. "Mr. Jennings, what is going on?" I explained the situation while Patricia stood there with her arms crossed, looking defiant. Deputy Martinez took my statement, then Patricia's, then spoke with the bulldozer operator who had wisely stayed to give his account. "Miss Hendricks," Deputy Martinez said, "you attempted to have someone destroy property that you have no legal claim to. That is criminal mischief and possibly attempted vandalism. I need you to come with me." Patricia's face went pale. "You cannot arrest me. I am the president of the Pinewood Lakes HOA. We have rights to this property." "Madam, a judge already ruled that you do not. You are under arrest. Please turn around and put your hands behind your back." Watching Patricia get handcuffed and placed in the back of a patrol car was one of the most satisfying moments of my life. The two other HOA board members in the truck tried to slink away, but Deputy Martinez stopped them. "You two are witnesses. I need statements from both of you." One of them, a timid woman named Sharon, immediately cracked. Patricia told us she had legal authority to remove the track. She said the judge's ruling was wrong and that we had to take action ourselves. I did not think she meant destroying it with a bulldozer. I thought we were just going to talk to him. The other board member, a guy named Richard, nodded frantically. "Same here. We did not know she was going to do this." Deputy Martinez took their statements and let them go with warnings about being more careful about who they associate with. She turned to me. "Mr. Jennings, I recommend you get a security system set up out here. Cameras, alarms, the works. This woman is obsessed, and even if she gets charged, she might make bail." I took her advice seriously. That afternoon, I called a security company out of Bemidji and had them install a comprehensive system. Cameras at the entrance to my property, along the access road, at the track facility, and covering all the important structures. Motion sensors, floodlights, and a direct alert to my phone if anyone came onto the property after hours. The system was expensive, but after everything that had happened, it was worth every penny. And I was planning to add the cost to my lawsuit damages. Patricia was charged with criminal mischief and attempted vandalism. She made bail the next day, but the arrest had finally gotten through to the HOA board. They held an emergency meeting and voted to remove her as president. Several board members also resigned, not wanting to be associated with the liability Patricia had created. The new interim president, a reasonable guy named George, called me the day after the board shakeup. "Mr. Jennings, I want to apologize on behalf of the HOA. Patricia's actions were completely unauthorized and inappropriate. The board has voted to withdraw all claims against your property and to issue a formal apology. I appreciate that, George, but I am not dropping my lawsuit. Your organization has cost me tens of thousands of dollars in lost revenue, legal fees, and damage to my reputation. Someone needs to pay for that. I understand. For what it is worth, several of us are planning to attend the next HOA meeting to vote for dissolution of the board and restructuring of the entire organization. Patricia poisoned this community with her vendetta against you." The legal proceedings moved forward through February and into March. Patricia's criminal case was scheduled for trial in April, but in the meantime, our civil lawsuit was gathering steam. Robert had filed for summary judgment, arguing that the HOA had no defense against the documented facts of harassment and defamation. The HOA's new lawyer, a sharp woman named Rebecca Torres, was trying to distance the organization from Patricia's actions, but the evidence was overwhelming that the board had supported and enabled her throughout the process. The summary judgment hearing was set for mid-March. The day before the hearing, Rebecca called Robert with a settlement offer. "The HOA wants to settle," Robert told me over the phone. "They are offering $75,000 to cover your legal fees and lost revenue." "What about punitive damages?" I asked. "What about holding them accountable for what they did?" "We can push for more, but Frank, you need to understand something. The HOA is basically broke. Patricia spent so much money on lawyers and frivolous filings that their reserve fund is depleted. If we push them into bankruptcy, you might end up with nothing." "What about Patricia personally? Can we go after her?" "Absolutely. She is personally liable for the defamation and the criminal actions. We can pursue a separate judgment against her." "Do it." "The HOA can pay what they can afford, but Patricia needs to face real consequences." Robert negotiated hard and got the HOA settlement up to $95,000, which would be paid out over 3 years from their reserve funds and special assessments on the members. It was not everything I had lost, but it was something. Patricia's case was more complicated. She hired a new lawyer who tried to argue that she had been acting in her capacity as HOA president and therefore had qualified immunity. Judge Anderson shut that down quickly. "Miss Hendricks, you were acting outside your authority when you attempted to destroy Mr. Jennings's property. You were in direct violation of a court order when you continued to defame him on social media. You have no immunity for criminal or tortious conduct." The civil trial against Patricia personally was set for May. In the meantime, her criminal case moved forward. I had to testify at her criminal trial, describing the bulldozer incident and the ongoing harassment. The prosecutor, a sharp young woman named Angela Martinez, no relation to Deputy Martinez, laid out a compelling case. She had the 911 recording, Deputy Martinez's testimony, the bulldozer operator's statement, and the statements from the 2 board members who had witnessed Patricia's actions. Patricia's defense was essentially that she believed she had legal authority to remove the track. Her lawyer argued that she was not acting with criminal intent because she genuinely believed the HOA owned the land. Angela destroyed that argument on cross-examination. "Miss Hendricks, did Judge Anderson rule that the HOA had no legal claim to Mr. Jennings's property?" "Yes, but the judge was wrong." "But the judge did rule against you, correct?" "Yes." "And you were aware of that ruling when you hired the bulldozer?" "Yes." "So you knew that a court of law had determined you had no claim to the property, but you decided to destroy it anyway?" "I was exercising my rights as HOA president to protect the community by destroying someone else's property against a court order." Patricia did not have a good answer for that. The jury deliberated for less than 2 hours before finding her guilty on both counts. She was sentenced to 6 months in jail, suspended on condition of 2 years probation, 500 hours of community service, and restitution to cover my costs for the security system she had made necessary. But the civil trial was where the real reckoning happened. Robert put together a devastating case. He documented every canceled event, every lost booking, every hour I had spent dealing with Patricia's harassment instead of running my business. He brought in expert witnesses who testified about the damage to my business reputation. He showed the jury Patricia's social media posts, her violation of the restraining order, and the bulldozer incident. Patricia's lawyer tried to paint me as a wealthy outsider who did not care about the community, but Robert countered by showing that I had followed every rule, obtained every permit, and acted in good faith throughout the entire process. He also pointed out that Patricia's actions had hurt her own community by depleting the HOA's funds and creating special assessments for the residents. The jury was out for a day and a half. When they came back, the verdict was decisive. They found Patricia liable for defamation, harassment, tortious interference with business relationships, and intentional infliction of emotional distress. The damages were substantial: $300,000 in compensatory damages and $500,000 in punitive damages. Patricia went white when the verdict was read. $800,000 was more than she could possibly pay. Her lawyer immediately said they would appeal, but Robert had anticipated that. "Your Honor," Robert said, "we request that the court impose a supersedious bond to prevent Miss Hendricks from hiding assets during the appeal." Judge Anderson agreed. Patricia would have to post a bond of nearly $1 million if she wanted to appeal the verdict. She did not have that kind of money. Within 2 weeks, Patricia filed for bankruptcy. But bankruptcy does not discharge judgments for willful and malicious conduct, which is exactly what the jury had found. Robert filed to have our judgment declared non-dischargeable, and after another hearing, Judge Anderson agreed. "Miss Hendricks, you engaged in a sustained campaign of harassment and illegal conduct against Mr. Jennings. Your actions were willful, malicious, and in direct violation of court orders. This judgment will not be discharged in bankruptcy. You will be paying for your actions for a very long time." The bankruptcy proceedings revealed just how much Patricia had spent on her vendetta. She had racked up over $100,000 in legal bills, much of it on her personal credit cards when the HOA stopped paying. She had taken out a second mortgage on her house to fund the fight. Her marriage had collapsed under the financial pressure, and her husband had filed for divorce. Patricia's assets were liquidated to pay creditors. Her house was sold, her retirement accounts were drained, and she was left with a judgment that would follow her for decades. She would be making payments to me for the rest of her working life. The HOA itself was in shambles. The special assessments needed to pay the settlement caused several members to sell their homes. The community's reputation was damaged, and property values did drop, but not because of my track. They dropped because of Patricia's actions and the financial mess she had created. George, the interim president, actually turned out to be a decent guy. After everything settled down, he came to visit me at the track. "I want to apologize again," he said. "I should have stood up to Patricia earlier. A lot of us knew she was out of control, but we were too cowardly to confront her." "You are standing up now," I said. "That counts for something." Some of the residents were wondering if you would be willing to let HOA members use the track at a discounted rate, not as a right or anything, just as a neighborly gesture. A lot of folks in the community never had a problem with what you were doing. I thought about it. Part of me wanted to tell them all to go to hell after everything I had been through. But George was right that most of the residents had not been involved. They had just been passive bystanders while Patricia waged her war. "I will do a community day once a month," I said. "Free admission for Pinewood Lakes residents. They can come check out the track, see what all the fuss was about. But I am not giving the HOA any kind of formal arrangement or discount program. This is me being a good neighbor, not acknowledging any kind of claim or authority." George smiled. "That is more than fair. Thank you." The first community day was in June, after the snow had melted and I had converted part of the track to mountain biking and ATV use. About 50 residents showed up, curious to see what I had built. Most of them were impressed. The facility was professional grade. The environmental controls were obvious and well maintained, and it was clear I had invested serious money into doing things right. One older woman approached me near the end of the day. "I owe you an apology," she said. "I signed one of Patricia's petitions against your track without really looking into it. I just assumed she knew what she was talking about. I am sorry." "Thank you for saying that," I replied. "That is all I really wanted from the beginning." just to be left alone to run my business on my own property. As summer turned to fall and then to winter again, my business finally started to thrive. The publicity from the legal battle had actually brought positive attention to the track. Snowmobile enthusiasts from across the Midwest had heard about the guy who stood up to an abusive HOA, and many of them wanted to support my business. I hosted the Minnesota Snowmobile Association Regional Championships in February, and it was a huge success. Over 500 participants and spectators came to the event. The local hotels and restaurants were packed. I even hired several locals as staff, bringing jobs to the area. The track became exactly what I had envisioned when I first bought the property. A premier winter sports facility that brought the community together rather than dividing it. I expanded the operation to include guided snowmobile tours of the surrounding wilderness, a small lodge with food and drinks, and even a few cabins for overnight guests. Patricia, meanwhile, vanished from the area. After her house was sold, she moved away. I heard through the grapevine that she was living in a small apartment in Duluth, working a retail job, and still bitter about how everything had turned out. Part of me felt a twinge of sympathy. She had destroyed her own life over an obsession with controlling something that was never hers to control. But mostly, I felt relief that it was over. The legal battles had been exhausting and expensive, even with the eventual settlement and judgment. I had lost a year of my life and a lot of money dealing with Patricia's harassment. But in the end, justice had been served. The Pinewood Lakes HOA eventually did dissolve and restructure. The remaining board members voted to convert from a mandatory HOA to a voluntary neighborhood association with no enforcement powers. They focused on organizing social events and maintaining common areas, nothing more. It was what an HOA should have been all along. George became the president of the new voluntary association, and we actually became friends. He and his wife Denise were regular visitors to the track, and he helped me navigate some of the local politics when I wanted to expand the operation. 2 years after the legal battles ended, I was sitting in the lodge on a cold January evening, watching snowmobilers enjoy the track through the picture windows. The fire was crackling, the hot chocolate was flowing, and I could hear laughter and excitement from the riders. My phone buzzed with an email notification. It was from Patricia's bankruptcy lawyer. She had made her monthly payment toward the judgment. It was only $200, a tiny fraction of what she owed, but it was something. According to the lawyer, at the current payment rate, Patricia would be paying me until she was 90 years old. I deleted the email and went back to watching the snowmobilers. The track was packed with riders, the business was profitable, and I was finally able to enjoy the dream I had worked so hard to build. Patricia had tried to take it from me, and she had lost everything in the process. The irony was not lost on me. If she had just left me alone from the beginning, none of this would have happened. She would still have her house, her savings, her reputation. The HOA would not have been torn apart by special assessments and internal conflict. And I would just be another business owner running a winter sports facility in northern Minnesota. But Patricia had to have control. She had to win. And in trying to take everything from me, she lost everything herself. I raised my mug of hot chocolate toward the window in a silent toast. To property rights, to standing up to bullies, and to the sweet taste of victory after a long fight. The track was mine, built on my land, run by my rules. And nobody, especially not some power-hungry HOA president, could ever take that away from me. The door to the lodge opened, and a family came in from the cold, their cheeks red from the winter air and their faces bright with excitement. The kids were chattering about the track, begging their parents to let them go out for another run. I smiled and went to help them, grateful for the business, grateful for the life I had built, and grateful that I had stood my ground when it mattered most. The legal battle with Patricia and the HOA had been brutal, but it had taught me something important. Sometimes you have to fight for what is yours, no matter how powerful your opponent seems or how long the battle takes. And in the end, the truth wins out. My land, my track, my rules. That was how it had started, and that was how it would always be.